The goal is to talk about disclosure agreements and employment. This is sort of tangential to what's traditionally considered intellectual property, and we're viewing these issues from an intellectual property perspective. But in later life, most of you will be employed, and most of you will be faced with signing disclosure agreements or employment agreements. And so we're going to cover this topic today. First of all, it may be that you'll be hired by a small company that doesn't have a large legal staff, and so you wouldn't have signed an employment agreement, you're just hired. In that case, an employee has a duty to maintain the secrets of his employer and not to use them for the benefit of others or to disclose them to the public except as necessary to perform duties for his employer. This is true regardless of whether you signed an agreement or you had an oral agreement or you had no agreement. The only time it would not be true is if you had a written or oral agreement that would be in conflict with this. This is the standard default terms. If you're an employee, you have a duty to keep your employer's secret. You can't tell others about them without his consent or except as necessary to perform the duties for the employer. Now, the duty to maintain those confidences remains even after your employment terminates, but it does not restrain the use of the employee's skills of his trade in subsequent employment. So, person's secrets are to be kept secret even after you leave the employ. But you are free to use your skills that you gained in connection with that employer. Now, there are a few states, most notably Texas, that will enjoin later employment with a particular employer if the court determines in that state that it would be inevitable that the employee would use the prior employer's trade secrets in order to perform the subsequent employment that the person was hired to do. Most states do not have that rule, but Texas does. Sometimes there are specific agreements that are entered into. Now that's a hand-in for the homework. And that's the handout for today. There you go. Sometimes you have a specific agreement that deals with what you can do following the termination of employment, and that varies from state to state. Some employment agreements prohibit the employee from becoming an employee of another company during a limited time following employment, provided that that restriction is also limited to a geographical area and limited as to certain types of work. Covenants not to compete after payments for employment ends are invalid in some states, most notably California. So if you work for a California company or you're working in California, you cannot be compelled to sign an agreement that says you won't work for a competitor following the termination of your employment. In other states, Indiana and Texas, for example, you can be constrained if you agree to a reasonable prohibition against working for a competitor for a time period following employment. This is something you would want to think about pretty carefully, because when you first get employed by a company, you're all enthusiastic and whatever, and then the personnel person comes in and says, here are these 15 pages to review and sign on your first day of employment. And sometimes they'll have provisions that restrict your work for a competitor following termination, and that might affect whether or not you'll want to work there or what you would want to do in that circumstance. In virtually every state, other than California, which prohibits these kinds of restraints, the courts view them with disfavor. And so they have to be very reasonable in time, in territory, and subject matter. 1 year in a narrowly defined technology in the territory the company operates in might be reasonable in many states. There are some practical realities with regards to covenants not to compete. It may be best to decline further employment when an employer seeks to have you sign a post-employment covenant not to compete, depending on the scope of that. Covenants not to compete are reasonable for owners that are selling a business. Now, that's different than being an employee, and then you get laid off, and then you find you can't get a job at a competitor because you signed one of these covenants not to compete until you've waited the 1 year or 2 year period or whatever it is, and you have to go into a different line of work for a while until that prohibition subsides. But with regard to selling a business, if you're the owner of your small business, those kinds of constraints are enforced more regularly because you're getting paid a lot of money to sell the business, and they don't want you then to start the same business up again right after you've sold it to them. So that has a different rationale, and those covenants not to compete, particularly if accompanied by income payments during the non-compete period, are more likely to be upheld. Now, with regard to who has rights to an invention, and this is often misunderstood, in the United States, an employee who is hired to invent has a duty to assign to his employer all rights in inventions relating to his employer that hired him to make inventions. Some companies have inventor incentive programs to reward inventors either with a cash payment or increases in salary. Sometimes arrangements are made for ongoing royalty payments for inventions that employees make. But that oftentimes generates conflict of interest problems in that the inventor, employee, all of a sudden sees lots of places to incorporate his inventions in the product lines of the company, whether or not it's really in the company's best interest because he would get a percentage of the sales. So those are not so common in industry, although in academia they are more common, in particular at Purdue. Now, when an employee is not hired to invent, the rights in his or her invention belong to the employee. That comes as a surprise to employers on occasion. The employer will retain what's called a shop right to the invention if the invention was made using the company's time or facilities. A shop right is a personal, non-transferable, royalty-free right to use an invention. So if you're a company and one of your employees who's not hired to invent comes up with an invention and uses your company facilities or time to make that invention, then you don't ever have to pay royalties on that. You can use it to your heart's content for the life of any patent that might be issued or during the term of any trade secret that may subsist in the invention. But the rights in that invention belong to the employee, and the employee can then file for a patent provided that it doesn't violate his duty of confidences, as long as he isn't using secrets of the company in order to make the invention. He can file for a patent and then license the company's competitor and keep all of the money himself or herself. So that's what's surprising. We had one case involving RCA where they hired a temporary services person to come in and do some clerical work. And while they were there, they had a brilliant idea as to how to make video discs, which then was incorporated into RCA's video disc business. And our firm wrote the patent application for that temporary employee who signed no agreements. And RCA ended up being very kind to the employee financially in order to acquire that patent that they didn't have the legal right to just because that person was working there. They weren't hired to invent. They were there for some other reason, and they came up with the idea. So all large companies make it a routine practice for all employees to sign agreements agreeing that they will assign their inventions to the companies. Occasionally with the temporary hiring, that slips through the cracks and doesn't get covered by the standard boilerplate agreements. And smaller companies sometimes have this problem because they don't generally have the legal departments and the standard forms for employment. And so they may overlook this point.
So I have a good question. So if an employee then comes to you and you have to sign a, invention right to your company that you're being hired by, will that automatically have in there how they're going to handle a patent that maybe is produced off of something you invented?
It's up to the company to do it however they wish. That's not something that the inventor has rights to if he has a duty to assign. It's not his right. He gets his name on the patent, and he gets paid the salary, presumably, for having come up with the idea. But it's the employer's right, because the employer owns that right, because the person was hired to invent or signed a contract to assign. Now, if it happens that the person was not hired to invent and didn't sign any contract, then the employee gets to decide what to do at the employee's cost to file for a patent or to do whatever they want, and then you can have a business relationship and sell those rights to the employer, but that's open for negotiation as to how that would work out.
What constitutes hired to invent?
Normally engineers are hired to invent. That's why, but I suppose there might be circumstances where they would not be, but normally you hire design people to design things, and so that would be a more clear case of hired to invent. A case where a person would not be hired to invent is if somebody was hired as a secretary and worked typing letters, and they came up with an invention while they were doing that.
Is calling the job description engineer, is that enough to give up the right to product? There's like quality engineers which don't necessarily invent things.
Yeah,
quality.
That would be a gray area, and it would depend on the specific facts of the situation. Most, as I say, most large companies avoid that gray area by having you sign an agreement. So that doesn't come up too often with large companies employing that kind of personnel. Small companies don't necessarily have those different divisions, so you have more informality, and it's not quite so clear. And you also have a similar question hired to invent if somebody is a vice president or president or chief of somebody in charge of the people who invent. Does that make them have an obligation to assign? And again, those are fact sensitive, and you'd want to look at the specific cases to show how it's worked out in the particular state in which you're located for those kinds of things.
And just, I guess, as a new hire, and when you're looking at these documents, what's the best resource to turn to as far as understanding any legal jargon or anything that's maybe used or referenced as far as?
Yeah, I think you can pretty much tell from reading the agreements whether they have a covenant not to compete. Beyond that, they're pretty much standard agreements, and I wouldn't worry too much about them. The covenant not to compete is the one red flag that you want to think about. I know my son did a summer internship at Microsoft, and they had a covenant not to compete for 6 months. And that's okay because you're going back to school for 9 months, and so that would run out. And next summer you could go somewhere else. But for the regular employees, they had a 1-year covenant not to compete. And they're based in Washington, where covenants not to compete are permitted. They also have offices in California. So if you were working in their California office, that wouldn't be an enforceable provision, even if you signed it, because California just does not recognize covenants not to compete. It's a strong public policy. Now, as to all employment arrangements, the employer and employee can agree to a different way to handle trade secrets, copyrights, and patents. If the parties agree to something different than we're talking about here, that's fine. That can control. And those agreements can, in fact, be oral. They don't have to be in writing. But if they're oral, they're oftentimes harder to prove. So you'll like to have them in writing. But legally, they're just as binding if they're just oral and not written. Now, for small businesses, the inventor owners often have arrangements in which they personally retain ownership of the patent rights to achieve insulation from creditors and to achieve better tax treatment. Then they can license the patents to their company, and if their company should go bankrupt, they would still own their patents. So it's a good structure for small businesses where the inventors are the owners, is to not assign those patents to the company if they can do that. Sometimes people who loan money to companies would want the patents as security, and so that sometimes doesn't work out, but that's the goal. I think I've pretty much covered that. Often, two parties outside of the employment setting enter into a confidential disclosure agreement to promise to maintain confidentiality and limit the use of each other's trade secrets to a specific purpose. These agreements may be either in writing or implicit based upon the custom of the trade. A lot of times vendors and their customers will maintain their customer specifications in secret, even without a special confidentiality agreement, because otherwise their reputation would be ruined as a place to go. And so the custom in the trade enforces those confidentiality obligations. But that's unique to each trade, and you'd have to establish that. It's much better if you have a written agreement of confidentiality. Could be just a letter confirming that they'll keep things confidential. It doesn't have to be a formal agreement. Doesn't have to be written by a lawyer. But it's nice to have agreements of confidentiality for at least as long as it would take you to file a patent application, so you don't risk any loss of patent rights. Now, sometimes there are agreements between large companies and individual inventors. If you've come up with an idea and you want to go to a large company and see if they'll have an interest and pay you money for your invention, they normally have you sign standard agreements. These are routine, almost universal, where in order for the company to even look at your invention, you have to agree to limit your claims against them to those rights provided under the patent and copyright laws. And they require the person submitting the idea to the company to forfeit any rights under trade secret laws and under theft of business opportunity laws. So if you have in mind that you're going to take your invention to a large company and have them be interested in it, you'll have to file your patent application first, because they will not agree to take that information in as a secret and look at it. Now, if you're a famous person, have had lots of inventions, or if you're a large company and you want to deal with another large company, then you have the bargaining power to maintain trade secret rights in your negotiations with regard to new inventions. But for most individual inventors, they won't have that option. They'll have to first file for a patent to protect those rights, and then they can talk after signing these kinds of agreements that are normally required by the large companies, that you waive all rights except those under the patents and copyright laws. Normally, a non-disclosure agreement includes a provision limiting the use of the information to determining whether a business deal can be entered into or not. And then if a business deal is entered into, then there will be further obligations of confidentiality. But for the initial non-disclosure agreement, the sole purpose of that is so that each party can consider the issues without compromising the rights of the other party to obtain foreign patent coverage and without compromising the other party's trade secret rights. If the disclosee, after learning of the secret information, then conceives of an improvement to the disclosed information, the disclosee is prohibited from seeking rights until the disclosed information otherwise becomes public, or he learns of it from another independent source. It's sort of a tricky event that happens. You think, no problem, I'm going to keep what you have as a secret. You tell me what you know. They tell you what you know, and then you say, I know a really good way to improve upon that. But you're stuck because you've agreed not to use that information for any other purpose other than to working out a deal, and you're now thinking about that information in the context of a further improvement. And you're prohibited from doing that because you can't use that information that you just agreed to keep in confidence in this disclosure agreement, non-disclosure agreement. And I've seen that happen on many occasions where people happily sign these non-disclosure agreements with no concern, and then they get that information, and once they have that information, they're somewhat poisoned from further developments in those areas because they can invite a claim of violation of the trade secret rights. And as I say in the last bullet point, disclosee is placed in a difficult position of not being able to clearly do further developmental work in that area without placing the ownership of the further development in doubt. Now, with regard to invention records, there are all kinds of protocols that have been adopted for how to best keep invention records. And I'm going to describe the ideal to start out with. I'll then get to the realities later, but at least so you know what the ideal is. Ideally, you have contemporaneous dated records signed by the inventors, clearly detailing the conception of an invention, the diligent work thereafter toward reduction to practice or patent filing, and the reduction to practice itself if prior to patent filing. Now, under the new law, where it is the first to file that is most important as opposed to the first to invent, these become less significant in determining who's going to own rights in inventions where there are two separately filed patent applications. But they're still very helpful to have these records because quite often there are other people affiliated with the inventor who, once they see a really great invention, remember that it was really their own invention. And they sort of remake history. And to the extent you keep your records of conception and reduction to practice prior to the patent filing, you will enhance your opportunities for being the correctly named inventor, which carries with it prestige and oftentimes awards within large corporate compensation practices. Now, shortly after the original records are made, they should be dated and witnessed by two persons who are not the inventors, who are each technically competent, and who state in writing that they have read and understood the records. And having those two witnesses as an independent verification of the inventor's work tends to resolve questions of inventorship much more effectively than if you only have the inventor's own documents, which in theory could have been done after the fact and predated or whatever else. But having the two witnesses really helps secure that evidence of invention. So that's the ideal. Ideally, you keep the original records in a bound notebook in ink with consecutively numbered pages so people can't change things around. Ideally, you avoid the use of negative terms in any invention record, suggesting that any approach is to be abandoned or concealed, or particularly you don't want to say that this can't work or it can't be made, or you have no idea how to make something. You don't want to say the negative things. You want to say positively what happened when you're keeping your record, what you think will happen and why you think it will be good, including mention of reasonable alternatives to consider, as well as the specific design that you are working on, is really very helpful. Okay?
So what's the purpose of that, in case your invention records now become public
They will become public.
and what, used against you?
Yes. They will. And you really didn't have the idea, did you? The idea that you later perceive and understand, but at the time you're just, this is all formative. And so whenever you say negative things, they're going to be in a record where somebody else is going to say, this guy didn't even understand this alternative. He says, you can't even do it. That's the way I solved the problem. And so you're taking away your options later on for optimizing your position with regard to the invention by putting negative things in. I mean, you can point out why your invention is better than the alternatives. That's great. That's implicitly saying the alternatives are bad. But it's much better to spin everything in a positive light in terms of how everything looks 10 years later when they're dredging through those documents in some big court trial. You rarely help yourself by saying negative things about your own work in writing. Good records make it easier to correctly determine inventorship. This is really important. Sometimes inventorship problems get very personal, and it's somewhat like divorce proceedings, or where people really have these intense feelings about whose idea it really was. And having those records there will diffuse those high emotions that happen from time to time with regard to who should really get the credit. Good records will make it easier to resolve the questions of derivation. And derivation contests are what will be used in the new America Invents Act for determining which of two applications should prevail when one was before the other, yet the later filed application owner will contend that the prior filed application was stolen from them and filed improperly, and you have a derivation contest. And so then people are going to look at the invention records to see who in fact came up with it first and who derived something from somebody else. And those dated records will help resolve those very efficiently. Now the reality. Having learned the ideal, the reality is the early patent filing is often the most important record. So forget about keeping invention records. If you can actually file the patent, that solves all the problems, because then you have that early date. Because patent rights are largely based on the first to file. And so if you're spending a huge amount of time making invention records and you're not spending that time writing patent applications and filing them, you may be misplacing your time. Second bullet point, and this is really true. Often, very good inventors keep very poor records, as creativity does not necessarily correlate with careful record keeping. Some of the most brilliant inventors I've worked with over the years have kept virtually no records. There's another category of really good, brilliant inventors who keep really superb records, and those are fine. They're covered no matter what. But some of the most brilliant minds seem to be bogged down with the record-keeping part of it. And so if you take them away from their inventive focus and force them to do the record-keeping, that may not optimize their happiness in their setting, and it may not optimize your life. You really want to keep those good inventors happy, however you can. The best way to do that is down at the bottom, is pair them up with somebody who's a really good record keeper who may not be quite so inventive. And you put them together as a team and things will work just fine. Getting a project done on time may be more important than documenting invention dates. I've been involved with patent prosecution for 42 years and have had, I think, perhaps 3 occasions in 42 years where there has been an actual interference between 2 patent applications. And as it has turned out, in none of those cases did the invention record make any difference. So, at least from my sampling, it's very unlikely that the invention record will matter. I can say I've had several times where invention records have diffused conflicts between claims of inventorship, and those have served the people well who have kept those records, but not with regard to actual interferences between separate entities. Generally, the time it helps resolve them is within a large corporate entity where there are different groups that are working, and then there are paper trails that you can follow, and that diffuses the issues. Sometimes records can hurt as well as helping a case. Where comments are made in the record keeping, that differs from arguments that are made for patentability in the patent application. The person who comes up with the invention might write comments down, and the patent attorney who writes the patent application may want to slant the arguments in a different fashion. So the patent application gets filed within one perspective, and the records maybe have a different perspective, and then when that patent gets litigated, then somebody's going to go through and see the inconsistencies and try to make something out of that. So the reality is it's not quite so important. Any other questions? Okay, we are done.